Good afternoon, everyone. Welcome to round 3 of Medicaid Mondays in March. And we're going to be talking to you today about Medicaid home care. This is a series that builds on itself. So the first session was basic Medicaid eligibility. The second session was Medicaid asset protection trusts. Today, we're going to do a full 60 minutes on Medicaid home care. The other two were 30 minutes. And next week, we're going to talk about Medicaid nursing home care. And where we have the most changes by far are in the home care area. And there are things that we're going to talk about today that are really in as fresh as you can be. They're going to go into effect on May 1st. We have a series of changes that went into effect November 8th, and we'll have more changes after May 1st, which we're going to talk about as well. But in order to get us going, I want to turn it over to Frank, who is one of our many attorneys, and you'll see our cast of attorneys here. And these are New York City and Albany based both. And we cover, if you don't know our firm, we do elder law, Medicaid planning, trust planning, but we also do business succession, high-end estate planning, tax planning, and other trusts. So that's our firm. We're a boutique firm, as they say, and we do things in the Medicaid realm, which is what we're going to talk about today. When we're talking about Medicaid in our world, primarily, we don't do a lot with basic healthcare Medicaid or the exchanges. People can figure most of those things out on their own. Where it takes an attorney to get involved is when Medicaid turns up to long-term care, and you look at the long-term care benefit under Medicaid. And when it comes to paying for care, and Frank, we talk about these expenses all the time. What are nursing homes running now?
Roughly $15,000 a month. If not more.
15 to 16. I'm seeing more 16
Yep.
with the surcharge
Yep.
on.
Sure. If you add the 6.8% tax, yeah, you're certainly going to be pushing higher numbers.
So that's $192,000 a year. And not many people can afford that. So there are things in the budget that we're going to talk about as well. The governor's budget and the two houses, the Assembly and the Senate, both put their one house budgets out. So we're going to talk a little bit about that towards the end as to what's coming and what may be in this year's budget, which is very different from what has been in past year's budgets, where we've always been talking about cuts. Now we're talking about expansion of eligibility. So something that is going to be discussed over the next several weeks while the budget discussions go on. So when you're looking at long-term care, there are really only 3 ways to pay for it. If you're going to pay for it yourself, that's out of pocket. So you have to have enough income and assets, and call it $200,000 a year. How long could you afford to pay $200,000 per year? When you get beyond your own pocketbook, hopefully you've had the foresight to buy long-term care insurance or one of the life insurance products that's excellent at covering the gap between what your income is and what your expenses might be in long-term care. And there are wonderful products that are out there on the marketplace. Long-term care insurance has taken a number of hits, but it is still viable, and especially on the life insurance side. The products on the life insurance market, in the life insurance marketplace, have indemnity benefits, which we think are the most valuable, where you get dollars that you can spend for any purpose and any way you choose in the event you need long-term care and you meet your triggers. But if your income and assets are not sufficient, and if you don't have insurance to cover it, there's only one place people turn, Frank.
Medicaid.
And that's to Medicaid. And we have to just point out this slide whenever we talk about Medicaid. Medicare and Medicaid are vastly different programs. They came in at the same time, both in 1965, both part of Lyndon Johnson's Great Society program. And in fact, when Lyndon Johnson announced the Great Society program, his quote was, "Never again will seniors in America have to worry about health care." And we know that not to be true today. The last 60 years or 50 some years have changed this landscape. People are living longer, the costs have gone through the roof, and Medicare is not able to provide basic health care for some, co-payments, deductibles. You have to have private insurance to back up your Medicare. But long-term care falls outside of the whole realm of health care. It's basically been carved out. And because Medicare does not cover long-term care, as Frank said, the only program that does is Medicaid. But Medicare is an entitlement program. Everybody gets it at 65. Medicaid is not. Medicaid is a means-tested program or a welfare based program. So we have very strict rules on how people can qualify for Medicaid. And Frank, in fact, we have several sets of rules,
Just a few.
two of which apply to nursing home care and home health care. And now we have a new set of rules that we have to learn for home health care. So just explain a little bit about the differences between chronic care and community-based Medicaid eligibility.
So the biggest thing is look backs, right? For a long time, we counseled people. There was no look back for home care, and there was a 5-year look back for nursing home care. That's what's been in flux since October of 2020. And even before then, when those rumblings started and those laws started getting signed and getting passed. So the biggest change now that we're seeing is there's much more of a they're synced up much more now, where there will be a look back for home care. There will be the existing look back still in place for nursing home care. The question is, what does the look back for home care look like? How does it work? When is it enforced? And just a lot of other questions that go just with the other medical piece of home health care, not looking at eligibility, but the actual implementation of the services. What do those things look like too? And we don't have a lot of those answers yet.
And Frank, we have a lot of different home care programs, in fact, in New York State.
We do.
What are some of the programs that you work with? And Frank is our primary Medicaid attorney. He does Medicaid applications every day. He's very versed in home care, chronic care, and all the planning that goes into it. Frank, what are the programs in home care that you work with, and some of the subtle differences?
Sure. So the biggest things that we use home health care, right? And we use either through a managed long-term care company or the Consumer Directed Personal Assistance Program. We also do quite a bit of planning with the Nursing Home Transition Diversion Waiver Program. We do more ALP, assisted living facility planning with Medicaid as we get more facilities in this area that will accept Medicaid, but we still don't do a ton of it. Sometimes we do things just as you kind of mentioned at the start of just getting people health insurance. We don't, although that's not the primary place that we see. And then we do a lot of planning for chronic care, crisis plans, promissory notes. That's for next week.
That's the nursing home side of things, because up until this new rule, this new 30-month look back goes into effect, and we don't know exactly when that is. Department of Health has indicated that it may be July 1st. But the reason we don't know when it is because if we have another round of infections, COVID infections, we may see an extension of the federal moratorium on Medicaid changes, which has pushed this back. These rules were supposed to go into effect on October 1st of 2020, but because of the pandemic, they have been pushed back. Certain rules went into effect. The final regulations came out back in September. Certain rules went into effect. We're going to talk today extensively about the rules coming up for May 1st, but other rules like the 2.5-year look back are not yet imposed and are still without a date certain, but we're thinking July 1 for this look back period. So we're going to talk about what happens today if you apply for Medicaid. But before we dig into that, Frank, run the numbers.
All right. So these are new numbers, right? I went over this on our first webinar in this series. So if you're an individual at home and you need Medicaid, your income allowance is up to $954 a month. If you have a couple where both are applying for home care, that has increased to $1,387 per month of income for both spouses combined. If you have a spouse in the nursing home and you are in the community, or they are receiving in-home Medicaid benefits, then you as the well spouse get that minimum monthly maintenance needs allowance number, which is now up to $3,435. And then we have our asset numbers or our resource numbers. If you're an individual applying for Medicaid, this has been increased by $900. So your asset allowance now for a single person is up to $16,800. Again, couple at home, you don't double that because that makes too much sense. So now we're up to $24,000 combined. And again, if you have that scenario where there's one spouse in the nursing home or receiving home care services, one spouse that is not, that community spouse, their asset allowance stayed at $74,820.
So a lot there. You went a little bit fast, but the numbers that we try to work with for a single individual who needs Medicaid, if you're at home, $954 per month is your income allowance. But there's a technique that we're going to talk a little bit about, a pooled trust that you can use to shelter the income over $954, and for a single individual, assets of $16,800. That's what you have to get down to live in the community, to live in your own home or an apartment, and to have an ability to get care brought into you. It is a welfare-based program for the moment. Talk about that later. But what happens if you've given assets away? It depends.
It does.
What does it depend on?
Depends on when. When did you do the gifts and for how much?
And
where are you?
and what program are you applying for?
Yeah, all these things.
So let's start with chronic care. That's next week's program. But in order to understand the rules that are coming for home care, you have to look at the rules that exist for nursing home care, because we have a 5-year look back for any transfers for nursing home care. We're going to have a 2.5-year look back for Medicaid home care implemented sometime maybe July 1st. What does that mean? That means that they're going to go back and examine transfers. And Frank, you do these applications along with our paralegal, Jennifer DeRosa. What's the level of scrutiny on that Medicaid application? How hard do they look at things and what are they looking for?
So, but basically, without a doubt, they ask for every transaction over $2,000 to be audited and to be proved. Where did those funds come from, or where did they go if you disperse them somewhere? And but the kind of the sneaky thing here is it's the county, and they're the deciders of what they want and how they want and what they ask for. So we recently had a case where we had a family that wanted to help their loved one, and they had very few transactions over $2,000. But there was a random one for like $1,400 kind of stuck right in the middle of the look back period. And they asked about that one to try to see what happened to that money, because it was so out of the blue, didn't make sense with really anything else that was going on. They asked us to document that one. They normally wouldn't ask for something that low, but because it was such, a difference than what was normal.
An anomaly.
Yeah, they wanted to know, maybe this was some gifting done, or maybe this went to a different account that we're not aware of. So they asked us about that. So unfortunately, there's no real easy answer for this question, other than if it's over 2,000, they will look at it, they will make us document it. And if you don't, then you get a denial if you don't explain it to their liking.
So when you're applying, you have to dot your I's, cross your T's, and explain every transaction over $2,000, and in some cases less than $2,000. Right now, the only program you have to do that for, though, is nursing home Medicaid.
Correct.
Chronic care. Home care, you don't. So what happens, Frank, if they find transfers within that 60-month look back?
So just to make this real simple, right? Because I know we throw a lot of numbers at you when we do these presentations. So just trying to make this simple, but just to illustrate the point, if we had a chronic care situation where we have to do 5 years of audits on your records, if we found that there was $150,720 total gifted away between all of your accounts, that's the number. We couldn't figure out where it went, or they were just outright gifts, right? Sometimes we have people that just say, I make gifts. That's what they are. So if you total up the total amount of gifts, then you divide it by the average regional rate of where you're applying. So in the Capital District, that number this year is up to $12,560. So if you do the quick division, 150,720 divided by 12,560, you get 12 months. And what does that mean? That means that Medicaid does not pay for your Medicaid services. So your services in that nursing home in this scenario for 12 months. That's a full calendar year where your loved one is in the nursing home, and they're going to get that bill for that $15,000, $16,000, $17,000 a month. And once you've paid that 12 times, then Medicaid will start. That's how the penalty works. That's how they're going to use it in a home care scenario. It just will be a less amount of time where they're looking back, but the penalty should work the same way.
So if you think about this, the way that the penalty triggers for nursing homes is you're in the nursing home. You have to be placed already. You have to be in the nursing home. You have to be otherwise eligible, which means your total assets, if you're a single individual, have to be under $16,800. And then you apply for Medicaid, and then they assess this penalty. Well, if I've given those assets away 4 years ago, and now all I have is $16,800, and I apply for Medicaid, and the county says, oh, you're ineligible for 12 months. Where does that $192,000 come from, Frank?
And that's always the interesting question when we talk to families when they have scenarios like this happen. If the funds are still available and can come back to the Medicaid person, then usually there's some more planning we can do once they've gotten the money back. But if they don't come back, either because they can't or they're not around any longer, then the question becomes, what does this look like for that person in the nursing home? And generally what happens, unfortunately, is they start accruing a private pay bill in that facility for that $15,000, $16,000 a month. And then typically what'll happen is once that person has a reason to go to the hospital or to get out of that facility, they get shipped somewhere else and that bed's given away. And when that person recovers in the hospital, when they call up the facility to say, hey, Mary's ready to come back, the facility says, well, she isn't coming back here because now we don't have a bed for her anymore.
So coming soon to a Medicaid office near you is a 2.5-year look back where those rules are going to be applied to home care. We did an extensive webinar last year on the Medicaid home care transfer penalty and scenarios around that. We'll be doing that again once we get a date where these rules are going to be implemented. But suffice it to say that there are a lot of open questions with how the look back 2.5 years would be imposed and how these penalty periods would apply in a Medicaid home care context. There are different regional rates all across New York State. That 12,000, it's 120% of the Medicaid reimbursement rate. So if you look at that as 120%, you would tell what Medicaid reimburses nursing homes, which is far less than that private pay rate. But that's the divisor. These are the different regions across New York State. And as we said, July 1, 2022 is the potential enforcement date of those new rules. And the look back is coming. We just don't know when, unless the legislature decides and the governor decides they don't want to impose it. We do have some guidance on the retroactivity of the look back, Frank.
So if you just look at the slide, right, we tried to make this simple because it's unfortunately it's a confusing topic with a lot of different dates. But if we do see the rules take effect as of July 1st, 2022, then when we apply for that home care person and the look back is there, what they're going to do is they're going to look back from July 1st, 2022, all the way back to October of 2020. If it's the following month in August, then we look back an additional month. So it's a 21-month look back for July of 2022. It's a 22-month look back for August of 2022. And that'll keep extending 1 month until we get to April of 2023, when we get to our full 30-month look back, or our 2.5 years. And then once we hit that number, so once we get to May of 2023, then they'll start going back to November 1st of 2020. So it'll increase, so it'll move 1 month in both directions. One less month to look back for every month that you move forward, just like the 5-year look back does now.
And this part of the rule is locked in. So any transfer made by any Medicaid applicant on or after October 1 of 2020 will generate a penalty if they apply for Medicaid after this new rule goes into effect. But as a practical matter, we may not have the rule until we have a full 30-month look back, the way things have gone due to the pandemic. Sure. They are not going to go back and impose this on reassessment. At least they have said they will not. So penalties that are done, or transfers rather, that are done by Medicaid applicants who applied prior to, and this is one of the keys, applied prior to the imposition of this new 2.5-year look back, there is no waiting. There is no look back. There is no penalty. All of these rules are future rules. The current rules still stand, which means that you can transfer assets, create trusts, and become Medicaid eligible right away. There are also certain exempt transfers. We'll cover these very quickly. You can transfer any amount to a spouse, and spouses still have a right of spousal refusal. So that has not gone away. You can put money in the healthy spouse's name. They can sign a piece of paper that says, I can't afford to turn these assets over. I need them to live my lifetime. And the Medicaid applicant will become eligible. There is a right of recovery against that spouse. So the county could come back and ask for money, contribution, or file a claim against the estate. So there is more planning needed beyond just the spousal refusal. You can transfer assets to a disabled child. That's an exception that we've used. And when that works, it works very, very nicely, because any asset can be transferred to the disabled child, depending upon what type of program they're on. You can create a trust and make the transfer into a sole benefit trust, which would qualify for the exempt transfer, or you could transfer directly if they're on Social Security disability, for example, which is a disability, but it does not have a means test to SSDI. You can also transfer to a blind child. And so those are the exception transfers. There are also excuses, if you will, or reasons that you may have made transfers. What if it's an innocent transfer? You're perfectly healthy. You give $20,000 to your church because they're building a new wing. 3 years later, you need Medicaid, you've spent all your own money, that $20,000 transfer could be a penalized transfer, and you would say,
I did it for purposes other than to qualify for Medicaid. I had no reason to think that I was going to be in need of this service. So therefore you should not penalize me because I had no reason to think that this would have ever happened.
yeah, if you're getting something back, you're buying things or you're transferring money for something in return and it's equal value, there's no penalty on that. It's only gifts, uncompensated. And if you give gifts and you get money back, you can in fact vitiate the penalty, you erase the penalty. So for clients that are doing this on a planning basis, we want to make sure the funds are still available in the event we need to do gift backs, and we use a trust very often for that to make sure those funds are there, and then we can pull the assets back out of the trust if we need to. Let's go back to home care because that's today's topic and look at income, Frank.
Sure. So the only way that this works, that a person can stay in their house, is if they get full use of their income in most circumstances, right? Because that allowance, while it keeps creeping up a little bit more every year, the allowance still sits at $954 a month. And very few people, if anyone, can live on $954 a month. If that's the only money you had coming in every month between your Social Security, your pensions, your IRA, RMD distributions. So the only way that this works is we use something called a pooled trust, right? And it's a type of trust that's created with a charity. There are special rules for establishing them and who can run them and what rules they follow when they have the money from the Medicaid applicant. But essentially, these pooled trusts can use any of your excess income above that 954. It gets put into an account in the Medicaid person's name, and then the family can use those funds from that trust to support that individual in the community for whatever they need, as long as it is for the Medicaid person.
There are a number of pool trusts in New York State. They are run by not-for-profits. We work with several, and they are a godsend. How people could do Medicaid home care without this, I don't know, because you have mortgages, you have rents, you have expenses, heat, utilities, food, medications. All of those things will be payable out of the pool trust, and it is a great thing. Question becomes, under the new rules, if we now have a transfer penalty, because the premise of the reason you could do a pool trust was there's no transfer penalty. But if you do have a transfer penalty, will pool trusts exist? Will they still be available to people under home care if there is a penalty period imposed on home care benefits for transfers of assets? And the answer is, to the best of our information from the New York State Department of Health, yes, pool trusts will continue to work. They have some guidelines that they said they need to work out because they want you to now have to drain the money out and use it for the individual's benefit on a month-over-month basis. That's one of the things that they were talking about. We're still awaiting more guidance on this topic, but the good news is that pool trusts appear to be protected and still available under the new transfer penalty rules. However, they're going to have some more restrictions on them in how the money has to come out and what it needs to be used for. So we'll wait and see. Again, those regs are not out yet. We're going to wait, see what the state does, see what the federal government does, and we will keep you apprised as we get more information. So as we look at creating Medicaid eligibility, right now, Frank, it's pretty easy.
Essentially, it's the same plan we've been doing. It's just there's a little more urgency with it. We're looking at getting that person down below $16,800 of assets before the first of the month, where we're going to apply for the benefits, setting up any planning we're going to do, set up that pool trust if we're going to do it, and all doing it quickly and getting that application in before these new rules start. Because as hopefully has been pretty apparent, once the new rules go into effect and they start being enforced, things change quite a bit.
So most people learn well through examples. So let's take an example. Meet Beverly. And Beverly has income of $2,954 per month. And you can see the 954 on there. That's a prearranged number. IRA of 75,000, savings and checking of 25,000, a home of 250,000, and $100,000 in stock. Beverly has done no planning as of yet, and she now needs Medicaid home care. The question becomes, when will Beverly be eligible for Medicaid home care benefits, and how does she get there? Frank?
We could get her eligible by April 1st as long as her broker is really good and really fast.
No fooling. It's not an April Fool's. So right now, yeah, we're at March 21st.
Yeah.
Happy spring, everyone, by the way. Hope spring brightens everyone's time and life up. How can we get her Medicaid eligible, Frank?
So we would create the Medicaid Asset Protection Trust. That's a type of trust planning that we do a lot of. It's irrevocable. I think you and Aaron did a whole presentation on that last
Yeah,
week.
if you want more information on the Medicaid Asset Protection Trust, it will be available on our website for last week's 30-minute video.
YouTube now.
It's on YouTube now. So you can go to YouTube and go to Pierro, Connor, and Strauss, and you can watch the Medicaid Asset Protection Trust 30-minute video. Okay, so we've got assets off the table.
Yep. And then we're going to create that pooled trust to take all that excess income off the table. So between the two trusts, then this is usually the way I have it in my head. Think of it this way. She has an income trust for her Social Security and pension. She has an asset trust for her house, her stock, her bank accounts, anything else that we got to put in there. So between those two trusts, we get her down below 16,800, get her income down to the 954, and we're good to go.
And she's Medicaid eligible. She has her income available to help defray other expenses. And she has her assets in a protected trust, and Medicaid comes in and pays the bills. Now we're going to turn to what does Medicaid actually pay for and how do those rules, or how are they changing, which is substantial. But the financial piece of this, until those other rules come into effect, is the old rules still apply. So there is still time if you have people that are perhaps in need of Medicaid home care and are not quite sure, now's the time to get an assessment done and to figure out whether they can apply and get in under the old rules, the existing rules. April is going to be a great month to apply for Medicaid home care because not only do you get in financially under these criteria, but you'll also be under the existing eligibility rules. And we'll talk about those in a minute. The whole process, the whole darn thing, started taking 4 months, 5 months, 6 months to get service in the home. And if you're discharging from a hospital and you need to be home with services, there's no way you can wait. So because of all of the hurdles that were put into the system when MLTCs came in, the state had to find a remedy and had to give a fast track for Medicaid applications, and that's immediate needs.
Which we try to use whenever we can, because we understand, right? Just like you kind of alluded to, Lou, right? Not everyone has those 3, 4, 5 months to wait. So when we can use immediate needs, we do. The counties, for a period when this all came out, they weren't really sure how it worked either. Luckily now we have much better success with working with the local counties to make sure that these are fast tracked, and we should have that decision within the 12 days. If there are any issues, clearly working with somebody like us can help make sure that there are issues, we keep them going where they need to go and get that remedied ASAP. The biggest question here is the bun on the bottom, right? How do all these new rules that we're starting to talk about, and then we'll go through a little more with some of the other changes, how does this get affected by all that stuff? And we're not really sure still, because there's so many different pieces involved with the new process. I'm not going to say new players, it's the same people just doing different things. Is this still going to work the same way? And we don't know that yet.
And when you think about how this process has evolved, it all used to run through the County Department of Social Services, the LDSS, Local Department of Social Services. And they were great. They processed, they were local people, they knew the local families. So you had a connection and you had an ability to communicate and file those applications. Not that they weren't contentious at times, but it was somebody that you knew that was doing the intake and the intake process. When they shifted all of this, they left the fiscal analysis right with the counties, and they still have that, and they're still going to have that under the new system. But they moved the analysis of what are people's needs to manage long-term care companies. Certain things stayed with the counties. The fast track application was one where the county had a lot more say in how that application processed, because it didn't require an MLTC evaluation. So who does the evaluation in an immediate needs application?
The county.
The county nurse, health nurse.
Yeah, so the county typically can get their people out quickly. And then once you're approved, then you're in the immediate needs program. Then you have kind of a grace period where then you kind of hang out under the immediate needs program. And then once some time has gone on, then you're required to then transition over to MLTC and eventually get off the county's caseload, if you will.
So there is more documentation required, and we're going to see that that's going to continue through the new rules. And there's one key critical fact in how immediate needs is going to play out under the new rules on May 1st that we'll get to in just a moment. But now we're going to shift gears and talk about the current changes to the Medicaid home care rules. We've talked about the broad landscape, the different programs, personal care, CDPAP, nursing home transition diversion waiver, other waivered services programs, all different, all unique. We have the managed long-term care program where you have MLTCs doing analyses and evaluations and assessments. We have always had Maximus, since they put in these new MLTC rules, doing what was called the conflict-free assessment. If anybody knows what that is, it is an assessment at the beginning to say that someone has sufficient need to be in the long-term care system. And then it flips over to the MLTC to do a second assessment to determine the actual needs for care and to establish a budget for that care and award the hours. And the hours are the holy grail, Frank.
Yeah, unfortunately, we're getting more and more reports from clients that managed long-term care companies are not awarding hours in high degrees. Certainly not without fights, appeals, doctors getting involved, additional medical documentation getting involved. It's one of the reasons why we rely so hard on the person's treating physician, a care manager, if it's appropriate to get a care manager involved. Sometimes the attorneys get involved. And in the past, we've had to take cases all the way up to something called a fair hearing, where we actually litigate the issue before an administrative law judge just over the hours determination. So I think in people's minds, everyone gets really scared and worried about the qualification piece. And that's still kind of the easier piece, right? Especially up until the new rules come around, because we can do all the things we've been doing for quite some time now. But once you get through all these hoops, you've done your trust planning, you've done your Medicaid application, you have your approval, you've gotten assessed, and you're standing there waiting for the home care to come into your house to help you. And now you're going to get 4 hours a day when you need substantially more help. And now we have to talk about potentially going before a judge to litigate it out to see how many hours we can get you.
So most consumers are more familiar with the financial aspects of Medicaid. Very few consumers are schooled in how the assessment process works and how much you need advocacy through that process. Those that know me know that I am a big fan of care management, what used to be called geriatric care managers, now called aging life care coordinators. The national association is ALCA, the Aging Life Care Association. And these are professionals, many of whom are trained in Medicaid and advocacy, who can help go through this system. You may know that we do an elder law forum every year. And last year we did a panel on home care, which is available on our website. And there is a care manager on Long Island who is probably the best in the business at advocating through the Medicaid home care process to get the number of hours that you need. And at the time she did it, Suzanne Paolucci is her name. And Suzanne was undefeated. She hadn't lost a hearing. And what your first shot out of the cannon from an MLTC a lot of times is, oh, we can only give you 4 hours a day. That's it. But the doctor said, I need 24. Well, we can only give you 4. That's our limit. And then you start the appeals process, and preparing for that appeals process is critical, and an aging life care coordinator can help you prepare, because as you're going to see in these new rules, even the primary care physician is taken out of the equation. So let's dig in. September 8th is when the rules were published. There were 60 days till the effective date. So November 8th came, and some of the rules were imposed on November 8th, but the majority were not. So we now have a whole set of rules that are going to change the entire system. It's really a change in the whole way that the assessments are done and that people are processed through the Medicaid application process. And what we're looking at is a new independent assessor. So I said earlier that there used to be 2 assessments where you had Maximus, that is the conflict-free assessment up front, and then you had either the county or managed long-term care company doing assessment of the number of hours in need. Now there is just one. Maximus is doing something called an independent assessment. They are contracted with New York State to do every assessment in every long-term care, home care Medicaid program. And so now the MLTCs and the counties, the LDSS, will have very different roles in this Medicaid application process. So the community health assessment, there's supposed to be a new tool that I haven't seen yet. I don't know that it's been published yet.
No, that's actually one of the things that we think is actually going away.
Okay, so they're going to do some type of universal community health assessment, which would then go back to the MLTC and the county to develop a plan of care. So we have to really drill down on this once we see it to see what's in this community health assessment. And it will be an initial assessment purposes only, the community health assessment, which is then combined with a medical exam and a practitioner's order. But this isn't a medical exam by the individual's physician. In fact, the rules and the regulations say that it's prohibited to use any physician that knows the patient in any way, shape, or form. So this has to be an independent physician selected by New York State. Haven't seen the roster of doctors yet who are going to be performing this function come May 1st. But come May 1st, Maximus goes out and does the community health assessment, and then it goes to a physician. Wouldn't you think the physician should do the review first and inform the community health assessment? But that's not the way the regs are working. You're going to have Maximus's assessment. Then you're going to have this independent physician who's going to conduct a medical exam and develop a practitioner's order, and an independent review process for those seeking personal care, CDPAP, or managed long-term care eligibility. So this is an independent assessment for people over 18, and other things along with reassessments are going to be put off, not implemented on May 1st. So this is only initial assessments for adult applicants. And there was to be this new assessment tool, but the budget, if passed, would abandon that. And we're waiting for new guidelines and standards to be issued to direct what this independent assessment is going to look like. So we're still without a certain amount of information, but the process and the people, or at least the offices, not the doctors yet, no names, but independent physicians, are going to be part of this. So along with having a new independent assessor who's going to be conducting this upfront assessment, and we'll get more detail on that as we go, we have an independent physician who's going to conduct a medical exam and do a practitioner's order. And then we also have an independent panel of physicians. So this is where your doctor gets taken right out of the equation. And if you can't use your own doctor, how do you support your case? So there is going to be more prep work necessary, and you can't put the physician's records in. It's going to be an independent physician. But when you go to appeal, Frank, what wins on appeals?
The biggest thing are family members testifying just to everyday experience, doctors' records, and other treating people, and they that care manager if they're involved. Because between those three people, right, you've got boots on the ground in the home, the family talking about what their experience is like providing care every day. Then you've got sometimes other medical evidence, whether that's in-person testimony or medical records from that person's treating physician for the past 15 years, whatever it is. So the judge can go through all those records and really get a sense of what does this person look like medically from a paper standpoint. And then if you have that care manager involved, they can then turn around and say, I'm seeing all of these things. I've met with the family. I've been in the house. I see what they have to do. This person really is in need of X number of hours per day. That's the only way they can remain in their home and remain safe. And between those three pieces, you pretty much have a winning argument as long as you can get it all together.
Yeah, having done this type of law for 38 years, anytime there are changes, there's litigation. We've had major changes all along the way. In 2006, we had major federal law changes, which put the new look back and penalty period rules in. And we litigated a lot of those issues through fair hearings and all the way up through the courts, the Supreme Court, and all the way up the appellate division. I've argued in the New York State Court of Appeals twice on Medicaid issues. And we're anticipating as these new home care rules go into effect and people don't get the services that they need, there's going to be a need for appeals and a need for litigation. So we're ramping up to be part of that. There are attorneys across New York State who will be part of that. We're going to have one of those attorneys who is the champion in this area, Valerie Bogart, who is going to be part of our Elder Law Forum once again, which is going to be on May 19th. So that's a date you may want to mark down on your calendar. It's from 8:30 to 3. And we have excellent practitioners and people coming from all across New York State, and including the representatives from the Department of Health, Adam Herbst, and the Office for Aging, Greg Olson, several legislators. But Valerie Bogart really digs into this, and she is as knowledgeable as anyone. She'll be there and then we'll have 19 days of experience with these new rules if they have in fact been put in place on May 1st. So your doctor out, independent practitioner panel, some physician who's going to come in and do an examination, issue a report in. That report goes then back, because remember, the independent assessment has already been done. So these things go back then to the county and the managed long-term care company to review, and we'll talk about what their role is going to be from that point forward. Anytime you have this, we already had an MLTC system we mentioned earlier that put 3, 4, 5 month delays into getting care and getting service in the home. When you now have this one company going out to do all of the assessments in New York State, you then have an independent physician panel that has to do a medical examination and issue a report for every Medicaid application in New York State. It then has to go all the way back and go back through the channel of either the local Department of Social Services or the managed long-term care company to do their work and develop a care plan from all of those things. What could go wrong? How could this go off track? We're expecting delays. We're anticipating delays. So remember the immediate needs program. We're going to come back to that in a minute because there is some more play there for immediate needs. Once you get through with the independent assessor and the independent physician, now you go to an independent review panel. They're all perfectly independent.
Just when you thought you were done.
But they all work for New York State. How independent does that make them? So the review panel is going to review every case where you need 12 hours or more of care. And they're going to review it not only on a health basis, that there's a need for more than 12 hours of care. So now you got this independent doctor panel. How well do doctors know home care? How well do they know what an individual's needs are? Social needs, social determinants, the ability to live at home. What's going to be the result of this? But not only are they assessing on that basis, they're also assessing on a safety basis. So they are going to make a determination. These doctors who are reviewing papers are going to make a determination where it's safe, whether it's safe for that individual to live in their own home. And that's going to create some issues. So again, these things are well-intentioned. They're designed at the time. Remember, this was 2 years ago budget. And they were designed in 2020 to cut $2.5 billion out of Medicaid. So they're designed only to do one thing, and that's to ratchet down the amount of care that's being expended through the Medicaid program. So these rules are now finally coming to fruition 2 years later, but here they are. And these are all rules that keep us from advocating and representing people by using their own physician, by using a care plan developed for them. Everything's taken out of the individual's hands. A Medicaid applicant has no say. They have to go to the independent assessor, the independent physician, and the independent review panel. That's where everyone's going. So I'm fearful anytime you take this kind of a system and put it into hands of people that don't have any connectivity to the people that need the care, you're going to have bad results. So we'll anticipate it. We're preparing for it. There's going to be litigation. And if the plan is determined to be reasonable and they need the care to be healthy at home and they're safe with 24/7 care, I suppose that 24/7 care could still be implemented. It's still available under New York Medicaid home health care. We get it now fairly regularly for people who truly need it, but it's going to be much, much tougher to get those benefits. So the ADL requirement is put off for a little bit. So this is something that they said may come in down the pike a bit, and it's something that is not there yet. But this is, again, raising the bar, making it harder for people to get Medicaid home care. Right now, it's 2 activities of daily living. It's going to go to 3 activities of daily living. And people with dementia or Alzheimer's currently can get types of housekeeping services with one ADL and a cognitive diagnosis. That's going to 2 activities of daily living that they would need assistance with. People who are already on should be grandfathered in. And as we said earlier, if anybody that you know may need Medicaid home care, time to find out is now, before the new rules go in May 1st. Well, the whole assessment process is going to change, and before the fiscal rules go into play, potentially July 1st, along with these other more stringent home care standards. So there is some legislation to try to fix this. There are Assembly and Senate bills, which you see there on your screen. It's in red because it's hot and it's being debated as we speak in the legislature. And if repealed, the individuals would be qualified to receive services if the applicant was determined following an assessment to be in need of home care services or private duty nursing and is self-directing or has a representative to make informed choices regarding their care based upon the existing rules. So, other concerns: managed long-term care companies can now disenroll people. And there are certain things here that become concerns. So if people are changing MLTC plans, which sometimes you do because you need to switch providers, there are certain rules, Frank, that now are going to be catching people by surprise.
Yeah, I mean, the biggest one here when we put these slides together that always makes me very nervous is that failure to pay your spend down. Just because if there's one issue that I think our office sees more often than not when it comes to spending down with managed long-term care companies, is that people will repeatedly receive invoices from their managed long-term care company for months and months and months and months and months after they've been spending down property to the approval trust. And we provided that documentation to both the county and to the managed long-term care company. So if they have the ability to throw people off their plan for failing to spend down, and we see the budgetary issues of just not being able to keep accurate records, that's a disaster. That always has made me very, very worried.
Very concerning. So if you have questions, and there are going to be scads of questions, I know that I'm part of the elder law section of the New York State Bar Association. The executive committee is studying all of these issues. There's a legislative committee that's working on legislation. And so we're following it very closely, but there still are a lot of knowns and unknowns. I don't know which are worse. The knowns are pretty bad. The unknowns could be worse. So we're going to see where all this goes. If you have questions on the independent assessor issues, that's the physician panel, or Maximus, you can write to independent.assessor@health.newyork.gov. And our friends at the New York Legal Assistance Group do a marvelous job advocating and tracking this law and the rules and the implementation of the rules. That is Valerie Bogart's organization. And the NILAG website is something we use as a primary research tool because they are on top of the game and they publish the same day when new regs come out, new rules come out, and not just regs and rules, but letters from the Department of Health that you may not have access to. I highly recommend the NILAG website. And next steps, Frank?
Get your planning done, please. Or if you think that there's somebody who could really be in need of potential planning, like Lou said, get that assessment done, get the ball rolling if you can. Because this is, as Lou has mentioned several times now, this is just what we know. There's so many things still outstanding that we don't know. And I doubt that the things we don't are going to be better and make this easier. Because clearly everything that's been put in place through all this time is generally just trying to make this harder. So if you can get in under these rules, please do it, or at least please look into it.
And if you're younger and you're a caregiver for an aging parent, think of your own planning in terms of buying insurance products and looking at structuring your financial plan to meet these needs for yourself, because we don't know how long Medicaid is going to be able to keep up with the pace of the workforce shortages, the inflationary factors on wages, and the number of people needing care. You have all of these things influencing what the next 10 years are going to look like. And it's pretty difficult when you look at the numbers, raw numbers. So do your planning, have some private financing available. Whether or not you can pay the full cost of care, have the ability to hire some home health care on your own without going through the Medicaid portal if you can. But if you need Medicaid, prepare and do the planning far enough in advance. Again, our Elder Law Forum, highly recommend it. Something where we're going to be exploring all of these issues with advocates, the state representatives, and people who are in the trenches doing this on a day-to-day basis. So we hope you can join us. It's going to be both live. We hope you can come to the Desmond. We're going to have a live presentation with breakfast, lunch, and a lot of networking involved as well. That's 8:30 to 3 on the 19th of May. We're also going to stream it live. So if you're not in the Albany area, you don't want to travel to Albany, then we can make you a participant via the internet. Go figure. So modern times, we're all zoomed out. So this will be a Zoom and live webinar. And I just want to touch base on one thing before we close, and we do have some questions from you. So we'll leave a few minutes for that. But on March 4th, just about 2 weeks ago, a little over 2 weeks ago, the New York State Department of Health issued a letter, and it is the implementation date and additional PCS CDPAS regulatory changes. And it's several pages explaining what the new regulations are doing, the process, the independent assessor, the medical exam after the assessment by the independent physician panel, the independent medical panel, which is going to do the more than 12-hour assessment and review. So one question I had when I saw this, Frank, was what's left for the local Department of Social Services and what's left for the managed long-term care companies, because they're still part of the process. And as it turns out, quite a bit. They have a section here that says they're going to review all of the other available services and supports to determine cost effectiveness. So they actually have to know the patient and do a review of that patient's other available resources. They have to determine the frequency of nursing supervision required, determine the individual's preferences and social and cultural considerations for the receipt of care. It's a lot of work. Heightened documentation requirements for 24-hour cases, and the development of the plan of care. So the whole plan of care, after Maximus does their work, after the independent physician does their work, then they're going to do a plan of care. I would submit that it's better to do the plan of care first, but you're not going to get that from the system. So a lot of work still for counties, ton of work, and the MLTCs after Maximus gets done, after the independent physician gets done, and if it's a more than 12-hour case, after the physician panel gets done with all of their work, then it gets kicked back for all of these further assessments and the development of the plan of care.
And Lou, we shared this, a link to this letter in the Zoom email everyone got at 11 a.m. And it's also on our website resources page, if you want to read it.
And I just want to point one more thing out, and then we'll go to the questions. And I highly recommend, if you haven't seen it, to read it. And that is, it's amended to align the immediate needs process with the new assessment process. So we were wondering how immediate needs was going to align. An individual must first provide to the LDSS a statement of need for personal care services from a physician with direct knowledge of the applicant's condition. How about that? They brought your doctor back in the immediate needs process. So we're going to continue to file everything we can possibly file under immediate needs, because we go back to our own doctor and we can do a plan of care, and we can do what used to be called the M11Q, which is an affidavit from the physician, which tracks all of the Medicaid regs, and it's a task-based assessment as to what that individual's actual needs are for hands-on care. And that's how you support your application for the number of hours, whether it's 4, 8, 12, or 24. You want to have it well documented, and in immediate needs, you get to use your own physician to do it. So that's the door that we want to take our clients through. And they have to attest that the individual has an immediate need. Well, anybody who's coming out of a hospital, anybody who has urgent needs for care is going to meet most of these criteria. And that's something that you need to know and you need to be aware of. It puts it back on the old track. So even after May 1st, immediate needs are going to use the individual's physician and plan of care, which is a great alternative. So with that, that's the end of our formal presentation.